of Erode branch, CAR Jayakumar ma'am, chairperson of Madurai branch, the managing committee members, and all the members of Erode and Madurai branch for taking part in this virtual seminar. Once again, I welcome you all to this insightful virtual seminar. I now request the chairperson of Salem branch, CAS Harini ma'am, to welcome the gathering.
A warm good morning to all the members present here. I take this opportunity to thank our speaker for today, Mr. V.S. Jayakumar sir, for taking time through, and I have been interacting with him for the last 15 days. The amount of time that he has spent for this next 2 hours is really enormous, and I am looking forward to have a great learning. And the session is planned in a way where a lot of question and answers are put inside the seminar, the PPT. So I request all the members to make use of this session and ensure you have a lot of takeaways from this next 2 hour session. I heartily welcome each one of you to this seminar. Thank you, Soumya.
Thank you, ma'am, for your warm welcome address. Before moving on to the session, I would like to take a moment to introduce today's speaker to all of you. Mr. V.S. Jayakumar was enrolled as an advocate in 1977 at the Madras High Court and has now been designated as a senior advocate in 2023. To be precise, he is the only senior advocate in Madras High Court from Salem. He was awarded the C. Vijayaraghavacharya Memorial Scholarship Award during his study period at Salem Law College. Sir has presented articles and papers in various forums like ICAI, ICSI, Revenue Bar Association, Hindustan Chamber of Commerce, to name a few. I take pride in letting you all know that he is the only advocate in Madras High Court who has presented a case during the COVID-19 pandemic through a PPT for almost 3.5 hours through the online mode. He has authored a book titled Authority for Advanced Ruling in Direct Taxes. Mr. V.S. Jayakumar sir has also held various posts in several institutions. He was the president of the Revenue Bar Association, Chennai, from 2007 to 2009. He was also in the editorial board of Chartered Accountants Study Circle in 2007. Many senior chartered accountants from Salem were instrumental in shaping him as an advocate in the early days of his career. With a small introduction, we now request today's speaker, Mr. V.S. Jayakumar sir, to kindly take over the session. Over to you, sir.
Thank you. The chairperson, C.S. Harini, A.G. Premilata, Secretary, Salem Branch, Mr. Ashokan, chairperson, and Vijay Kumar, Secretary of Erode Branch, and R. Jayakritika, chairperson, and Mr. R. Chairman, Secretary of Madurai Branch, distinguished chartered accountants, delegates, ladies and gentlemen. I have great pleasure in participating in this web lecture meeting organized by the ICI, hosted by Salem branch of SIRC in co-hosting with Erode and Madurai branches of Chartered Accountants Institute. I thank you all for giving me the excellent opportunity to share some of my thoughts and experiences on the topic allotted to me. I wish to particularly personally thank C.A. Suresh for extending invitation to give this lecture and choosing this topic. Though I am covering only the Black Money Act of 2015, whatever we are going to deliberate and discuss will cover about 9 to 10 enactments covering black money as a point, in addition to our Income Tax Act. So I must record my appreciation for the organizing team, especially your chairperson, S. Harini, and others who showed their excellence in organizing this meeting by following up with me frequently and ensuring that everything is in order. Kudos to all of you. The topic given to me, Navigating the Black Money Act, 2015, Essential Insights for Professionals with real-life case studies. See, this topic is of considerable importance at this juncture when the country is faced with tremendous amount of litigation in the light of electoral bond case and the litigations which knocked the doors of the Supreme Court with all ramifications and make this topic which we are going to discuss for next 1 hour, 1.5 hours today, more interesting. This topic is of practical importance to each one of you because you would have come across several litigation on a day-to-day basis from now on, or you're going to face from now on. And it's relevant for all of us, either as a litigant, advisor, chartered accountant, lawyer, or other professionals dealing with such matters. I'm also personally benefited because I made a thorough research of the topic, which is very, very handy to me at the right time when the courts are going to close in a matter of 1 month. So I propose to cover this topic in about 34 slides, out of which 2 are video clippings. And as I go on, I will explain to you. And as Harini said, and it's open to each one of you. If you want to ask questions then and there, I'll also get a feedback from you. But I propose to spend exactly 2 minutes per slide so that you will have a much broader spectrum of the topic. Next slide, please. Harini, next slide. The theme of the lecture I repeated to you is the Black Money Act, user-friendly or not. I thought of taking it, the topic, the theme can be whether it's draconian, whether it is not draconian, whether it is antisocial, whether it is, enriching the black money launderers and so on. Finally, I decided that the topic should be user-friendly or not for various reasons. I will explain to you as the slide proceeds. Next slide. See, Ram Jethmalani in the year 2011, for the first time, contested before the Supreme Court that there are several evils of black money going around the world. And the Supreme Court and the division bench on 4th July 2011 was dealing with the scope of information relating to unaccounted monies held in secret bank accounts outside India. Now, how far this has to be divulged? What is the balance between fundamental right of a citizen to seek information and fundamental right of a privacy of account holder? Are the names of those where no presumption or wrongdoing, whether to be disclosed or not? All the aspects have been deliberated. Now, the Supreme Court, in the end, they say that in these matters, fragmentation of government and expertise and knowledge across many departments, agencies, and across various jurisdictions, both within the country and across the globe, is a serious impediment to the conduct of a proper investigation. It is in fact necessary to create a body that coordinates, directs, and where necessary orders timely and urgent action by various institutions by the state. The continued involvement of the court in these matters in a broad oversight capacity is necessary for upholding. This is what he achieved in the Supreme Court. The next slide. Next slide, Harini. I was supposed to present the video clipping of Ram Jethmalani's lecture. It is too long. So I'll do it at the end in case there is any time available. Now, the act scope of BMA is slide number 6. Now, Arani will show the title of the act. See, the title of the act is in black money, within brackets, undisclosed foreign income, and assets, close brackets, and imposition of Tax Act 2015. When I made some research, what do you mean by the word imposition? I'm reminded of what happens in our school days where teacher says, I'll imposition, I will levy on you. So the word imposition always in our mind, in the layman's mind or a non-lawyer, is that it amounts to a penalty. It's not, it's more like a punishment. It's not user-friendly the way you assume it to be. It is maybe equal to levy. It may be a confiscatory. It may be addition to Income Tax Act, or it may be dehorse Income Tax Act, or it could be a equalization levy for that matter. So the word imposition of tax is a very dicey word. And right or wrong, there are 12 words in this particular title. In fact, only the Commercial Courts Act, first time introduced in the parliament, had 23 words. Nobody could read, including Shankar Mahadevan, in one breath. You could not read that title. They cut short it as Commercial Courts Act. this Black Money Undisclosed Foreign Income Assets Act is also equally longer. So I was asking Harini, why are you giving me a topic that's so long when I'm going to speak in this seminar? So I took a deep breath in the morning, but I had a cough, so I could not read it properly. That's why I put it in that slide. I did not put it. Now, taking along with this particular slide, there are a few aspects to this particular title. The intention of the legislature from what you read in the preamble, what we call preamble, according to Supreme Court is preamble is the eye of the mind of the legislature. If you read the preamble, you should know the scope of the act. For example, if it is Indian Penal Code, it is penalty. If penal code, if it is Income Tax Act, dealing with income. If you say Wealth Tax Act, it deals with wealth. If you say Gift Tax Act, it is gift. If you say money laundering. So the disclosure, the title gives the indication of the scope of the act. Now, what is the intention to tax is the foreign income and assets. These are the two things. That means non-foreign income, non-assets held outside without foreign source cannot be brought to tax. Now, kindly come down to they received the assent. This received the assent of the president. It received the assent of the President of India on 26th May 2015 on the right side corner. Now, why I'm mentioning this date is a much more serious view on this. On right side on top, 26th May 2015 is the date of the assent received from the President. Now, kindly come down. In every enactment, you have the preliminary, which is short title and commencement. It extends to whole of India, and it says comes into force from 1st April 2016. Now, kindly mark this date. 1st April 2016 is the date on which it comes into force. In other words, it does not come into force prior to 1/4/16, though approved by the President or assent given on 26th May 2015. Now, what really happened in this act, very peculiar, is that they've issued two notifications giving effect from July 2015, 1st July 2015. In other words, the act is backdated by notifications, mind you, notifications, not the amendment to the act. And it was brought into force from 1/7/2015. And almost 644 declarations were over by September 2015, even the act came into force. This is a paradox of the entire enactment. Now you kindly come back to the slide, Harini. Back to the slide number 6. So the question is, the moot point is the third arrow. At the time of enactment, the new law was stated to come into force on 1st April 2016, was subsequently antedated 1st July 2015, not by amendment, but by notification. So the question is whether it's retrospective, retroactive, and whether two notifications are sustainable in law. So the question came, and there was a further amendment changing the status of resident and ordinary resident and NOR by a retrospective law, mind you, from what date? The date is from 1st July 2015. So if you look at it straight away, the persons whose status was changed by the Finance Act 2019 was put in a worse position by a notification retrospectively. Come to the next slide, please. The amendment in 2019 was the residence, the definition on the left side is old law, and the right side is new law. So this law, section 3, applies only to residents and ordinary residents of India. In other words, if a non-resident has black money abroad, this law does not apply to him. Apparently, the objective of the law is to bring back into India the black money held abroad by Indian residents. This legal position arises out of the definition of an assessee. BML makes a new definition of assessee, which is different from the definition of the Income Tax Act. Only when a person is liable to pay tax under this law, that is BMA, he is an assessee. Since a non-resident or a not ordinary resident is not a necessary under this law, BML does not apply. This is very, very clear if you read section 3. Now see the new law on the right side. By the Finance Act 2019, retrospective effect from 1/7/15, not 1/4/16. If a person is a not ordinary resident, but was a resident under the Income Tax Act in the year to which such undisclosed foreign income relates to, or the undisclosed asset located outside India was acquired, then also such person would be falling under definition. This clearly shows persons who are falling on the right side were taken by surprise by a retrospective amendment, which is not challenged. Now I'll go to the next slide. Two interesting cases came before the Delhi High Court and Karnataka High Court, and matter went up to Supreme Court on this very issue. Gautam Kaitam case, they challenged the notification on 1/7/2015 and 2/7/2015 as illegal and ultra vires, null and void. The interim order of the Delhi High Court said that when section 85 and 86 gives them the power to issue a notification, how can the central government issue a notification even before the act came into force on 1/4/16? You're naming a child even before the child was born, thinking it is a boy. So it's something very, very strange and very awkward. So Delhi High Court passed an interim order saying that you cannot proceed with the BMA notices. Interestingly, as I mentioned to you about the Finance Act 19, definition is substituted. That is being contested in Karnataka High Court, Madras High Court, and even in Delhi High Court once again. Now, flouting of retrospective or retroactive provisions, which all of you are knowing about this, Ashish Agarwal case where 44 ATR page 1, where Supreme Court invoked Article 142 of the Constitution and justified the issuance of notification. So up to this point, it's very clear the courts accepting the lower courts. The higher the court, the leniency in favor of the government is very, very evident. Now, what happened in this particular case in Supreme Court? Against the Delhi High Court on 16/5/19 of Gautam Kaitan, which is the arrow number 5. The Delhi High Court, Supreme Court said, you have challenged only the notification. In other words, the Supreme Court said Delhi High Court did not deal with the retrospective effect. So the notification is valid, go back to Delhi High Court. I mean, this is completely a mockery of the proceedings. You're driving back to the litigation, back to the original stage. Now, there are interim orders of Madras High Court and Karnataka High Court, which dealt with proceedings under Section 3(1) proviso, was challenged, and the court have granted stay. Next one. Next slide, please. Yeah. The Bombay High Court considered Gautam Kaitan and in WPC number 1300, etc. in 2020, distinguished Gautam Kaitan and said, look, there is an anomalous situation. Since the declaration under 59 was to be made on or before 13/9/2015, and tax and penalty to be paid before 31/12/15, which periods were over even before the act came into force from 1/4/16. Therefore, this date appearing in 1/3 was substituted, and the date of giving effect was notified as 1/7/15 to enable the persons desiring of taking benefit under 59 of the Black Money Act to avail the benefit. So now the approach of the government and the court is, if it is benefiting to you, why do you want to contest? I mean, by and large, even then the Delhi High Court said it is not legally sustainable. The next slide. Now I'll come to the doctrine of fairness, a principle of legitimate expectation, natural justice principles. Now, what is this doctrine of fairness? See, Delhi High Court had another interesting case, which I did not give a citation here, is a case where a person came to know that the government is going to take action against him. So he voluntarily filed a declaration under BMA. Now, right or wrong, that BMA was rejected by the BMA authorities. And thereafter, this man thought he's become clean and there's no issue with the government. To his surprise, again, another notice came. He rushed to the Delhi High Court and raised all the plea. And one of the argument was, in BMA, if your declaration is considered and rejected, you lose the jurisdiction under BMA. So one of the interesting arguments was raised for the Delhi High Court. But Delhi High Court said there are other aspects of constitutional validity. So they linked up the case to a larger bench. Now, in the Act, in the BMA Act, there is a reference to Civil Procedure Code. So discovery, inspection aspect by the Civil Procedure Code is also permissible for the assessing officer to assume jurisdiction. Now, what is this discovery? Supposing I pledge a property and my documents are at the bank. Now, income tax officer can simply say that this property does not belong to you. You can directly write to the bank and say, I want to discover the document or inspect this document. CPC is also permissible. Now, this is which you all know that any income tax officer can do. What is so special about this BMA Act? The problem is if the moment you trace your Aadhaar number or your PAN number, the artificial intelligence gives you all and sundry information peculiar to your transaction, which you are involved or not. I had 3 interesting cases before the Madras High Court where a power of attorney was appointed whose PAN number reflected in the original power given by the seller. He also happened to be the power agent for the buyer because his buyer was his wife. Now, this transaction revealing the Aadhaar number or PAN number of the power agent, the artificial intelligence made this a 3 different transaction and taxed him not on the commission portion, but on the value of the transfer made of the property. His commission was only 2 lakhs. He was slapped with a tax amount of 40 crores. So I rushed myself to the High Court and I tried to argue before them. And they say that this is a very good point you have made, but it is a matter of fact. You go before the department, we'll give you 15 days time, let them cross verify. And if what you say is correct, let them drop the whole proceeding. It came back to department and is lying there. Now, another case where also a similar discovery inspection document was placed before the High Court in a civil proceeding, just showed as marked as an exhibit, which was rejected. That document was taken by the tax authorities and said, you had the liberty of filing before a civil court. So more the reason that you have not shown to the income tax department will catch you. Now the next slide. Yeah. I'm going to discuss about 7 enactments in this one slide. Binomi Act, Money Laundering Act uses the word transaction. Voluntary Disclosure Scheme in 1976. VSVS, recently, I'll come back to you on that. Samadhan Scheme, Income Disclosure Scheme, then Pradhan Mantri Garib Kalyan Yojana, Demonetization, Black Money Act, and Electoral Bonds. Now, this PMGKY generated 5,000 crores and tax collected was 2,500 crores. 1,250 crores is interest-free deposit for 4 years. Demonetization, 13 to 14 lakh crores in circulation in 16 November. Black money was supposed to be 14.86 lakh crore rupees. It was a total failure. Then Finance Minister recently said foreign accounts unreported income is about 8,468 crores has been brought to tax. Penalty of 1,294 crores has been levied. Black Money Act, mind you, is only 644 taxpayers. And only 2,428 crores have been collected. But this is a very, very, I use the word draconian act. As I go on, I'll explain to you how draconian it is. The income declaration scheme fetched 65,620 crore worth undeclared income in the form of cash and other assets being declared. There are also litigation pending in court as to what do you mean by self-assessment, what do you mean by amount paid on account, what do you mean by refund from the department, what do you mean by on-account payment. Then electoral bonds is 29,000 application. Now the next slide. Now, the interesting point is, kindly go back to, okay, I'll run through the slide, then I go back. See, it says that the act will apply to the whole of India. There is no definition of the word India either under this act or under the Income Tax Act or under Constitution. In Constitution says India means. It does not say means and includes. Or when this in the definition of interpretation provisions, if the act says it means, that means it is, if today is considered Saturday, it means Saturday, that's all. But the Constitution says it means Saturday, but also something may be acquired during the course of the day, that also may be Saturday. So we don't even know what is the territory of India. So we are talking about a case where it is a foreign income, foreign asset held outside India. We don't even know what is India. We are talking about outside India. So the territory of India, one case came before the Madras High Court in 215 ITR, where all these oil rig people, they come and work in the territorial water and maritime zone. The question was whether territorial water and maritime zone is part of India or does it exceed the nautical miles? If it exceeds 20 nautical miles, is considered to be outside India. The question was, can they extend every time the definition of territory of India by a notification? Palkiwala had given an opinion saying that you can't elongate the territory of India by a notification, and also you have no power to give a retrospective effect to the notification. This High Court, in which I was also involved in this 1995 215 ATR, the assessee won the case. I was for the department temporarily on a friendly note. Then the word assessee defined under 2.2 is different from the Income Tax Act. So an assessee who does not fall under the definition of BMA cannot be brought to tax under the BMA is very clear. Similarly, resident is also defined and different from the Income Tax Act and FEMA. So here also the flip side of it is, if you're not a resident or not an ordinary resident as amended by 2019 amendment, the Income Tax Act and FEMA are technically not included. Now, what is undisclosed asset? An interesting point is it is held. The word used is held in contrast to owned in section 211. The word held is interestingly is also used in the definition of short-term capital gain under the Income Tax Act. They don't use the word owner in section 245A or something. The word held, Madras High Court said, held means holding. So once you held, you can be holding it as a beneficiary. You can be holding it as a beneficial owner. You can be owning it as a person, as an accommodation. You can hold it as a passive income. You can hold it as a fraud or a money launder. So I want to give an example of Salem Town and Salem Junction as a journey, because I want to say that Salem Town Junction can be equated, let's say, to BMA, and Salem Junction can be taken as Income Tax Act. Now, I board the train in Salem Junction wanting to go out of India. I'm giving a very crude example. It may not be appropriate, but just to understand the subject. I don't buy ticket, but I have ticket from Salem Town to wherever destination I have. Now, what is the offense I have committed from Salem Junction to Salem Town? I violated Indian law. Now, when I go to Salem Town Station and board the train, I don't violate BMA. You take the reverse situation. Salem Town Station, I arrive without ticket, whereas I buy ticket from Salem Town to Salem Junction. So the point I'm trying to make is both Income Tax Act and BMA can apply by theory of proportionality to a given transaction. Take another illustration. Two persons, let's say Sri Krishna and I are in Salem. I sell a property to Sri Krishna. Property is in US. I pay the money to Sri Krishna in Salem, but the immovable property is outside India. Do I violate Income Tax Act? Do I violate BMA? Both of us do not show this transaction to income tax authorities in India, and both of us are non-resident. So the moot point is, because we are non-residents, Income Tax Act will not apply. Though the transfer had taken place in Salem, the property documents, etc., are outside India. This is example one. Example two, there are certain transactions which are legal outside India, but illegal inside India. For example, betting in Dubai of cricket T20 tournament is openly advertised that you can do a betting. And if I go and bet it, I win, let's say 1 crore dirham, and I don't bring it to India, it's a violation of both Income Tax Act and BMA because I am a resident in India. But my money is outside India, parked outside India. They can catch me under FEMA. So if I am caught under FEMA, BMA may or may not apply, but I can prove the source saying that I brought 1 dirham out of my Indian debit, Indian account debit. So in that case, is the transaction attracted BMA, or is it doctrine of proportionality, some here, some outside India? 212 talks about undisclosed foreign income. So there you must have a source and the birth of a source. It can be origin of a source. It is setting up of business. It can be passive income. It can be active income as well. Like there are cases where ESOPs are issued and quietly transferred, not disclosed. They are liable to Indian Income Tax Act. It may be taxed outside India. Depends on the DTA between countries to countries. Now, another interesting section here is section 83. It uses the word the BMA people can have an access to income tax papers. I don't understand what you mean by income tax papers, but the section gives you more details, but the heading seems to be very misleading. So I'm asking myself the question, does it mean income tax records? Does it mean dumb documents? I don't know if most of you know about what is dumb documents. Dumb documents are those in a case of search and seizure, means a voluminous document which are seized, which may also include numerous loose papers, diaries, notepads, which may contain rough calculation, vague notings, scribblings, and jottings, etc. There may be instances where such documents may also be non-speaking, so far as that such documents may not decipher with certainty or may not be at all, as the case may be, whether the document contains some transaction subject to tax, in whose hands, and all that. So income tax papers means even dumb documents, anonymous petitions, documents in the custody of third parties, because the word CPC says discovery and inspection, can also be roped in. Lastly, in this slide, I'm talking about impact of section 151 of the Income Tax Act, which talks about finding or direction given by court in any proceeding. For example, if Nirav Modi's case, just to give an example, the London court makes an observation. Under 150 subsection 1 of the Income Tax Act, the income tax officer can assume jurisdiction under the regular Income Tax Act and try to tax him world income for 16 years if he's a non-resident. Next slide. Now, again, the scope part of it is I've covered all this charging section, scope of tax, computation of tax base, assessment procedure, penalty. See, if you want to test a particular law is a taxing law or a fiscal law, few things are: what is the charging section? Does it provide for tax levy? What is the scope of the tax base? What is the computation? What is the assessment procedure? What is the penalty? What is the prosecution? Now, all this up to chapter 5 I mentioned tells you that this act is a fiscal enactment. Now, is it income tax per se? It is not income tax, even though it taxes the foreign income. Now, what is the line of distinction between this and that? That is where I'm going back to the topic, imposition of tax. It is in addition to income tax and not dehorse it. That's why the income tax officer or the BMA officer will pass two orders. One is 143.3, other one is under section 10. Now, chapter 6 is very interesting. Section 59 to 72 provide for voluntary compliance scheme. In other words, supposing I realize that my wealth tax return for 1970, I had shown a particular asset wrong. I could have come under this voluntary compliance and then showed my property in New York is shown to me as a world income. I can go under voluntary compliance even though I am a resident of India. This is a little paradoxical. This is very quixotic, but it gives you some sort of a leverage to the declarant. So again, all other provisions are, I'll take it if necessary on the scheme of the act. Next slide. Now, what do you mean by an interesting word used in section 10? The BMA officer can take information from the income tax authority or on coming of any information to his notice. Now, what do you mean by this information to his notice is very critical to work out the period of limitation. Notice, according to All England Report and Cresta Holdings, notice is not the same as knowledge. Notice is a word which involves that knowledge may be imparted by notice, but notice and knowledge are not the same thing. Although one loosely sometimes talks as if they act with notice and act with knowledge were indeed the same. So the word notice need not necessarily mean knowledge. Now go to the Indian Trust Act section 3 and 229 of the Indian Contract Act. It says that a person is said to have notice of a fact either when he actually knows that fact or when, but for willful abstention from inquiry or gross negligence, he would have known it, or when information of the fact is given to or obtained by his agent under the circumstances mentioned in the Indian contract tax also. Now, section 147 peculiarly in explanation 3 also uses the word information to his notice on coming information. It says not information, further information, or some language is used in 147. So even under the Income Tax Act under 147, there are two, caveat. Under 147, it should be a reasonable belief. I'm talking about the old law, I'm not talking about the latest law. Reasonable belief that income has escaped assessment, and further coming to his information and to his notice, the officer can invoke. So the Act knows the distinction between reason to believe of coming into any information to his notice. In other words, coming to information to his notice is very, very wide. Similarly, you find in the transfer pricing mechanism in 92 CA, also there is a reference to the word coming to the notice of the TPO. Now, an interesting judgment of the Kotak Mahindra versus Income Tax Settlement Commission, 458 India 113, the Supreme Court had an interesting dialogue as to when should I disclose my income. Should I need to be a person with black transaction? Can I come on my own? Kotak Mahindra had a problem in income tax accounting of lease accounting. Should they show the interest and overhead expenses in 1 year or spread over a period of years? Different chartered accountants said spread over is permissible based on some judgment of the Supreme Court, and some chartered accountants said you book it only in 1 year. Now the banks went for an income tax settlement commission. The settlement commission, the department objected before ITSC, saying that you don't have a concealment of any income or you are not making any disclosure. It's only an accounting entry. How can you come to settlement commission? Now the settlement commission agreed with the SEC and said nothing wrong. You're trying to reduce the litigation or paying the proper tax. Your petition is entertainable. So then, but when it came to penalty, they said penalty can be levied. So the SC went to the Karnataka High Court. Karnataka High Court said that, yes, we agree with you. Even a person with a straightforward deal can come to settlement commission. And Kotak Mahindra is right. Kotak Mahindra Bank actually is right in coming to the settlement commission. But when it came to penalty, they said the word concealment is obvious. You have deferred the lease accounting more than 1 year. That means you have not disclosed the relevant debit of the respective years, so it amounts to concealment. The matter comes to Supreme Court. Supreme Court says, who discovered what? Who disclosed what? Who concealed what? 3 questions were asked. The income tax officer discovered that all is not well because it is not an undisclosed income. So the court said, whatever he has discovered, whatever the officer has discovered is only accounting mismatch or accounting deferral, and it is permissible in law. But the banks came clean hands and said we'll pay tax in the year 1. Supreme Court said the word discover does not matter whether your point of view on department is one and the same. But when it came to disclosure, they made a fantastic analysis. The word disclosure means you should not have disclosed at all. Here, at least you have shown the accounting pattern. The only question is 1 year or 4 years. They made a distinction. Concealment can come only when there is non-disclosure. Now, why I'm pointing out these 3 words are coming to any information to his notice. There is no eminent indication as to what that information is going to be used against that. That is what happened in the Delhi High Court. A man went to voluntarily and filed a declaration even before the 1/7/2016, or rather 1 month after the notification came. It was rejected on technical ground. The Delhi High Court more or less indicated the jurisdiction is ousted. Now I'm comparing these words with the words we find every day. What is knowledge? What is inquiry? What is information? What is reason to believe? What is reason to suspect? There are several judgments of the Supreme Court. Reason to suspect can never be a ground for reopening. Reason to believe, and in today's latest law after 148A, any reasons they can reopen. Reason to gather is more than enough. Information should have a nexus. I'll come back to you on some citation. Inquiry is discovery and inspection. All these things will cover knowledge. So all these parameters Last two parameters is a check and balance in 147 is missing in BMA section 10. Gossip, rumor, pretense, assumptions, and presumption can be a ground for the word notice, according to me, because it's coming off any information. There's no filtering mechanism to show what is this information. If you compare this with money laundering act, they use the word transaction. Here, the word transaction is not there. You can be a passive owner. You can be a beneficiary. You can be, you're only holding certain things. You need not own certain things. All you have to do is it situated outside India? The meaning of undisclosed income is an interesting point. What happened in the Delhi High Court was one of the lawyers purchased an immovable property, and to his surprise, he found that there were some treasure in the property. To his surprise, when he was digging some sewage passage, he found an undisclosed income worth several crores. The income tax department surprisingly came for a survey and asked him, and this man said, "This is what we found." Then they said, "Is it undisclosed income?" He said, "I'm a professional, I'm a lawyer, and I continue to earn. I have not got this ownership at all. It's just part of the land." Then the question was, is it undisclosed asset? Then it is not undisclosed asset because he disclosed it to them saying, "This is what I found." Then the interesting point is, Delhi High Court said, you need not disclose this because if it is an antique piece, then go to Antique Act. If you go to some podayal you get or this treasure you get, it has no nexus to your income. So it's very interesting point to show what is disclosed income, what is undisclosed income, what is capable of being disclosed, what is not capable of being disclosed. An interesting argument is going on in the Supreme Court about this royalty case, which all of you can even watch in the YouTube. Royalty from mines and minerals. There was a case where two senior lawyers were discussing, Harish Salve and Mr. Parasaran. A property was given on rent to someone. The tenant did not know he had some mining materials in his ground. When the mining materials were noticed, he went and told the owner, "Look, this mining rights are yours." The owner said, "The tenant, the mining right is yours," because they were all good friends. They didn't know who's the owner. Then the government said, "It is mine." Then these two persons went and said, no, you can't take it. It's part of our land. When I sold it, it's there in the schedule, but I didn't know about this mining right. Then Parasaran and Mr. Harish Salve were exchanging notes. They were saying that the tenant sublet the property to another tenant. Then another tenant said, "It is mine." Then the tenant woke up and said, "No, it is mine." The owner came and said, "It's mine." So the paradox is, who should disclose certain income which you cannot even ascertain your own the source of the asset? Next slide. Next slide. Yeah. So now coming to FEMA, BMA, and Income Tax Act. If an income is taxed under the Income Tax Act, it cannot again be taxed under BMA. However, if the assessee is holding undisclosed asset outside India, it would be a FEMA violation. Hence, under amended FEMA, the enforcement officer can go ahead and acquire the assessee's Indian assets. If you compare FERA and FEMA, whatever is not mentioned in FEMA is permissible. Whatever is mentioned in FEMA is permission is required. In FERA, everything is violative. So that distinction can go back even though FERA is no longer in existence. Similarly, even estate duty, if there is a violation, looks like they can go back to even Estate Duty Act. They can even go back to Wealth Tax Act, though the Act says Wealth Tax Act will not apply. But in some other provision, they say some portion of the Wealth Tax Act can apply. In section 512B, it's very clear. Once an amount is considered as taxable under BMA, the same amount cannot again be considered as taxable under the Income Tax Act. This is where I'm talking about the Delhi High Court again, which says that even under the BMA, it was considered as taxable by me, but the authority said no. Then they can't even tax me on both the acts. I know Suresh is sending a message, estate duty is no longer alive. For information, they can still open. Estate duty has got no limitation. It's a very dangerous proposition I'm making. It is abolished. Gift Tax Act is abolished. Even then they can catch you under the gift tax if you had made some asset not known to the department. I know I'm making this thing. In fact, yesterday in Madras High Court, somebody challenged the fringe benefit tax, which is even withdrawn earlier. And some observations were made in an interesting aspect. Okay. 4.2, adjustments or additions made during assessment proceedings shall not be considered black money under the BMA Act. Now, if an addition is made under the income tax proceedings in relation to your foreign travel, etc., it will not come under BMA Act at all. Now, I'll give another example. Supposing I check out of Singapore airport. In the last minute, I'm eligible to ask for a refund of VAT which I have paid. Let's assume the VAT amount is 6 lakhs because 5 lakhs is the threshold for BMA. Now, I forgot to encash that VAT refund because I was in a hurry. Now, if I apply Income Tax Act, I have a foreign asset situated outside India, which is white, which I did not disclose under the Income Tax Act. So income tax people can catch me. Now, the Singapore government shares the information, let's assume, to the income tax officer and to the acting under BMA. He will say it is an undisclosed income because their government wants to pay to the Indian counterpart. So the officer has to call you and ask you, is it BMA will apply or Income Tax Act will apply? So such type of, I will suppose he makes an addition under the Income Tax Act. That does not mean it's automatically black money under the BMA. It's a white money, not properly explained by me, despite the source from Singapore, because I did not encash it. 4.3. Once an income or asset is included as black money under BMA, the same cannot be considered as income tax. Is debatable because I've told you certain things about Salem Junction and etc. Where do you commit the offense? So theory of proportionality, to proportionate to which the Indian territory and the proportion to other territory can be invoked. I'll give you a very crude example of 2 astronauts traveling in the rocket. Now they come and decide that they want to give a gift to his daughter, whose birthday happens to be on the day they left the world to the sky. Now one of the astronauts sends a message to the NASA and tell them, I want a gift to be given to person, let's say in India. And they located the product in Singapore that was packed in Indonesia, shipped from UK to India. Where does the transaction take place? Where does the territory of India? Who gives the command? The transaction is completed in India, or is it completed in the sky, or is it completed in US, or completed in Singapore, or Indonesia, or UK? This is all highly, highly debatable. After the e-commerce comes in, there is one provision which says that wherever there is mirror, what they call mirror in e-transactions, that country has got a jurisdiction to tax. In 20th century leasing of the Supreme Court and prestige case of the Karnataka High Court, which went up to the Supreme Court said the place where the contract is concluded can be taken as the territory. So if you do that, there are 4 transactions, 4 places it was ended, like some in Singapore, some in Indonesia, some in UK, and some in India, the product was received. If you apply the theory of proportionality, only 1/3 or 1/4 of the thing can be taxed, but the transfer is not within the territory of India. It is dehorsed territory of India, so nothing is taxable. No FEMA, no BMA, no ITA is one point of view. Next slide. Now, so far what I have discussed is the scope of the act, how it is draconian, and how it is not easy to take any position, and the importance of gathering the source of information and the relevancy to the proceeding under BMA and IT Act. Comparison of various schemes over a period of 4 decades makes us believe that black money has an important role to play in fiscal statutes. Public knowledge is limited. It's the professionals who should be familiar with such schemes and take a holistic view before advising the client. Educational profession through the seminars and conferences like this improves the awareness of the professional standards and to prepare ourselves for any contingencies that may arise only by comparing other similar statutes. Now I'll go to the next slide. Income Tax Act and BMA, when can operate? The law applies only to undisclosed income, undisclosed asset, consider 3(1)(e) and the proviso. Once an asset is disclosed, it is not tax based under BMA. Once an income has been disclosed, this law cannot apply it. This is the one straight, plain answer possible. There may be any amount of disputes during assessment proceedings. The assessee may claim exemption. AO may refuse the exemption. However, the income or asset has been disclosed. Hence, this law cannot apply. One interesting thing came to me yesterday was somebody claimed the status of resident and did not show an income of abroad. The assessing officer said, no, this is, your also comes under resident, but ordinarily resident, I'll tax you. So he filed an appeal. When he filed an appeal, the VSVS scheme came. So he paid some 1/4 or 1/3 of the tax and got away with it. Now let's assume that VSVS papers comes to this assessing officer, comes to his notice as information. Can he touch and disturb the VSVS? The plain answer is no. But if you read the BMA Act, it only says you can't tax if it is taxed under the Income Tax Act. You can't tax it if it is under the Wealth Tax Act. These type of special schemes are they part of the Income Tax Act? To my mind, a pessimistic view is yes, it's part of the Income Tax Act. You can't touch it. But see the amount of litigation. It can go further under the Binami Act, under the Money Laundering Act, under the VDS 6040 law, under the income disclosure scheme, or even under the electoral bond. Now, today, one client comes to you tomorrow morning, today or rather Monday morning. He says, I have got this bond purchased. Now, his name comes in the paper, let's assume. And let's assume that I am his legal advisor. Now, what precautions I must take and ask him, where did he buy it from? What source? Then he gives me that source, he gives me which bank, he gives me the Xerox copy of the document. Now, is it enough? So these are the steps which we'll elaborate in the next few slides. Next slide. Income Tax Act covers foreign as well as domestic black money, as I told you. Simple disclosure of foreign asset in the income tax return will not be sufficient because income tax returns being filed will be scrutinized under the existing Income Tax Act. Yes, while in fact, some of the old chartered accountants in this group will know. In income tax return, if you show it in part 3 of the income tax return, most of the courts have accepted there is a sufficient disclosure and penalty cannot be levied. Because part 3 was technically similar to book 4 of the registrar's office, where you can simply record any transaction, income, or whatsoever. So the next point is, once a person discloses an asset, he has to explain the source of income. Otherwise, 68, 69 will apply. TAO can add that asset to his income. And under BMA, the same can be taxed if the origin is outside India, whether it's debatable or not. Because 68 and 69 talks about books of account or non-maintenance of the books of account. When it comes to foreign accounts, even books of accounts is defined under the Income Tax Act. It includes computer CD, bank account, and so on and so forth. In fact, I had an interesting case for the Delhi High Court. When I file the return of income, that constitutes a record for the department. If I don't file the income tax return, there are no records at all for them vis-a-vis my income tax assessment. All other notice, reply, all this, you forget it. So if I make a mistake in my income tax return, if I file a petition under section 154, our argument before the Delhi High Court is mistake apparent on the face of the record. The argument of the department before Delhi High Court was, it is not your record, it's department's record. So the point which we took was, department has no record of mine, excepting in today's context, they got everything in the old context. Unless I file the return or evidence or whatsoever, there is no return of income which can be considered to be part of their record. So going back to this issue, under the BMA, can it be taxed? For instance, I forgot to show, or I show more in my income tax return. Can there be a refund from BMA? Certainly not. If I undershow it, for example, valuation, can the difference be taxed under BMA? The answer is highly debatable because the origin is outside India. Let me give the example of my betting in Dubai of the cricket match. I spent only 1 dirham or dinar. Now that has fetched me 1 crore dirham or dinar. Then when it comes to BMA, they say that the difference can be taxed. The value shown is only 1 because that's what you purchased for. Others are bounty. I can still argue it's not taxable in India. It's like a lottery case, or it's not an income. It's a bounty. It's a windfall. All that arguments are open to me, but they are not open to me in BMA. In BMA, only the source is relevant, assessee is relevant, location is relevant, and income is relevant. So lastly, the applicant cannot even disclose Indian sourced income under the voluntary compliance scheme. Very peculiarly, under 59 and 60, even in the same act, there is a voluntary compliance scheme. There, they don't mention whether you are a resident, non-resident, not ordinary resident, source outside India, asset outside India. Nothing is mentioned. There are certain conditions mentioned there. There should be under section 139(1). There should be time and all that. So once the money is lying outside India, he can disclose the asset as undisclosed assets held abroad. Now I'm repeating the theme again. Is this act draconian or not? Or is it practically user-friendly or not? To my mind, I am leaving to the audience so far to discuss this as we come along with the next slide. Next slide. In the computation aspect, I told you, a method of computation of the value of undisclosed has to be taken as the market value on the first day of the previous year. There is no deeming provision making past incomes as income of the previous year. Let's assume there's an opening balance on 2016-17. There's also assume that suddenly some refund comes in post 2016-17. Let's assume for somebody died in a plane crash. Compensation is received post 2016-17. There's so many possibilities where money can come in post 2016-17, and some cases before 15-16. The valuation is a matter of highly important exercise to be considered. Does it mean that it does not cover past concealed income? What about the past expenses not properly explained? Does it become automatically foreign black money income? Is a matter of debate. Next slide. Section 3 of the BMA states that any undisclosed asset located outside India shall be chargeable to tax on its value in the previous year in which such asset comes to the notice of the officer. It means there is no time limit for charge. So come to the notice of the officer. I'm giving you two examples. Let's assume one officer notices it, whom I knew very well. He noticed it and found there's nothing wrong with why should I invoke BMA? Later on, a successor comes in and he notices that it comes under BMA. The question is there any time limit for the charge? Can he review his predecessor or not? For example, if an asset has been brought by an ancestor some 100 years, sorry, I think you've come to the Q&A. This is a Q&A, no? Next slide. Next slide, Harini. No, earlier slide.
Yes.
Now I'm coming to computation aspects. I finished. Next slide.
After computation, it is closed.
Now I'm dealing with specific issues. Yeah, I'm dealing with specific issues. I'll read the question and I also read my answer. Section 3 of the BMA states that any undisclosed asset located outside India shall be chargeable to tax on its value in the previous year in which such asset comes to the notice of the assessing officer. It means there is no time limit for charge. For example, if an asset has been brought by any ancestors some 100 years back and the AO comes to know of it in 2024, does it mean that the charge at the current market value, is it not atrocious? This is where I am talking about the estate duty and acts which are even 1922 Act. My answer is yes, this is atrocious. There seems to be no time limit for assumption of jurisdiction. It's a reverse of retrospective amendment because retrospective amendment itself, I told you, notification 19 amendment, but this can be prospective for next 100 years. I think what the querist is right. It's highly draconian. Next issue, question number 2. Next slide. When the AO deemed to have the notice of, when is the AO deemed to have the notice of such asset? It's also highly debatable. I'm asking myself, is it awareness? Is it made known? Is it obtained? Is it gathered? Is it reappraisal? Is it review? Is it change of opinion? Is it external communication? Press report? In fact, if you see matrimonial sites, I will tell you interesting ones. Yellow pages, asset declaration before the statutory authorities. In matrimonial sites, we happen to see there are some boys and girls, they say, my father is worth 100 crores. And in yellow pages, there are some people, which is printed media, circulated a few years ago, also were looked into by department and to gather information. So the another facet is at what point of time and in which year he wakes up, on this notice comes to his knowledge. What if he omits to notice genuinely or highly subjective issues? It may be case to case. I can only refer to Lakmani Mevaldas Supreme Court in the context of 147A, where the Supreme Court still bearing on the question of escapement of income. Even this language is there in 147, even now in old law explanation 3. But when it comes to BMA, this is a guiding force. You can't simply ask for any information, and information can still be wrong. Next slide. Question number 3 and 4. Can an assessee would not declare the income from the foreign asset, file updated return, and wherever possible, before any proceedings are initiated by the assessing officer under the BMA, be able to file an updated return and save from rigors of BMA? The answer is yes, but refer section 83, which says income tax papers to be available for BMA. It talks about return. It talks about statement obtained or collected. Moot point is how far the department can stretch this section. The Madras High Court and Srinidhi Karthik Chidambaram is a very interesting point, and 411 ITR page 1. He's helpful because in that case, before the division bench, they demonstrated they had time to file a revised return, and they did file the revised return. Before the single judge, the issue was not that. The issue was, can the petitioner force the BMA authorities to extend the period of limitation in order to enable them to file a revised return? But they did not check the facts. So now it's become the law in the Madras High Court under the BMA Act itself that if you file a revised return under the Income Tax Act showing the asset, there in that case, there was an investment in Oxford by Karthik Chidambaram family, his wife. It was proved with a debit in the bank account, and the money trail was also done to the extent of paperwork. Added to that is the content of the revised return. The court said is reasonable. Prosecution is not possible. Then question number 4. The years, for years which the SC cannot file returns, will it be section 3? You are right on that. The persons who are administrating the authorities are one and the same. I know what Suresh is again raising the point. I agree. But according to one observation of Sampath Iyengar, one of the old edition, knowledge of one income tax officer is knowledge of the whole world. But that does not appear in the subsequent edition. I agree with him to that extent, but that does not mean that they cannot take into account the old record review. It comes to his notice. The word comes to his notice is very wild. So I agree to the extent that he cannot file the return to be hit by section 3. So the Latin maxim I'm quoting is lex non cogit ad impossibilia. You're not expected to perform into week. They will not allow you to file a revised return if the time limit is 1, whether it's under 139.1 or 139.4. Now, courts are taking a view 139.1 and 139.4 can have a different flexibility, but in a criminal prosecution in income tax case, Supreme Court is very clear, just not noticed by many, is that if the section says 139.1, 139.4 is excluded. Next slide. Question number 5 and 6, charging of tax at 30% on the value of asset on the date when the said asset comes to the notice, it was harsh because especially when the historical cost of the investment is low and the same defies logic. I agree. Logic and reasons have no role to play in income tax or in BMA. Another Latin maxim is cessante reger legis cessat ipsa lex, which means that reason of the law being at an end, law itself ceases. The reason is always the acknowledgement soul of the law. Here, the law is very, very clear. They want to tax you on the value of the asset when the officer comes to his notice. It's highly debatable, as I told you. Value of asset is a matter of dispute. There's always appeal. There's always tribunal. In fact, a few cases are coming up before tribunal all over India. 6, if an assessee is able to prove the source of investment, then as per section 211, the same is outside the scope of undisclosed asset. Will it answer question number 1? I have a very interesting observation of one of the authorities of evidence law. The rules of evidence do not necessarily ensure supposing they ask me to produce passport, I produce passport. Will mitigate the danger of injustice. Take a case where the passport is. So, if you're able to prove the source of investment outside India, even under Karthik Chidambaram's case, the High Court said it cannot become under undisclosed asset. It is in your favor. Question number, next slide. Question number 7, assuming that the assessee had opened a bank account, say $1,000 given by the spouse, who is a non-resident and non-Indian citizen with their own source in 2000. And the assessee had utilized the funds for investment in shares, earned dividend, and also made capital gains and not admitted by the resident Indian spouse. What should be the value of the undisclosed foreign asset? Is it when the same comes to the notice, they want what return should be filed? To me, the date on which AWO notices, it seems to be the relevant date. If the return cannot be filed, then the Latin maxim, as I told you earlier, and I also quoted Chitti and contracts, what they talk about impossibility. And only saving grace is penalty may not be levied, but if you can prove that your investment in shares or the dividend has already been taxed either partly or wholly, there is an escape route. But the caveat is, in Kotak Mahindra, if there's an accounting jugglery, don't take the gross, show only the ultimate net income. There's also a matter of debate whether have you shown the gross income, have you shown the net income. But under the BMA itself, they say the expenditures are not allowable. Set-off was not allowable. Carryover is not allowable. So to that extent, there is a mechanism which clearly says that the gross investment has to be proved. To this extent, there may be highly debatable issue. The source may be in 2000. But when it comes to his notice, so I'm relying on the judgment of the Supreme Court, not in 73 ATR, it is 74 ATR, which says that if you are not in a position to explain to the tax authorities, either through e-filing or otherwise, you cannot be penalized on the transaction. It is, the citation is 74 ATR, not 73 ATR, 183, where an interesting point came. A firm in which an assessee along with his children were partners. The question was, should in the return, should you show the name of the partner and the source of income? The Supreme Court called for the income tax manual for various years and found out that income tax manual did not contain a specific answer for this question for this assessment year before the Supreme Court. Whereas in the manual in the earlier years, there were guidelines. Manual in the subsequent years, there were guidelines. So the Honorable Supreme Court said, you can't find fault with a citizen when your guidelines is very, very silent in this regard. So I'm relying on this proposition of law to show that penalty will not be levied, but everything is a guesswork. Next slide. Another question on question number 8 is, the AO had information of foreign bank account and seeks details of the same. The AO furnishes now. Sorry, I'm not able to read that. Anyway, details of income for various years are represented in bank transaction. At what point of time AO decide about the income which is disclosed? Yes, I agree. And again, I'm saying that there are no guidelines, even though the circular is there. There's a conflict. The circular is not giving all answers, but the scheme is already over. There's no point. But once you have to contest it, the entire details are open. Again, relying on Karthik Chidambaram and information, bank account details have been furnished in that case. But if you cannot file a revised return on time, whatever you do is meaningless. Next slide. This is regarding penalty. Only 3 questions are here. AO may impose penalty for about 3 times the tax on the undisclosed foreign income. Is it mandatory or discretionary? The answer is, according to me, discretionary. But no officer will spare you. You will definitely 3 times. Section 42 says, where the SEC had not disclosed the foreign source of income and not disclosed the foreign asset every year, then the AO may direct the present resident shall pay a penalty of 10 lakhs. If the bank account for aggregate or bank accounts have a balance of less than 5 lakhs at any time during the year, provisions of 42 is not applicable. Can you elaborate? According to me, this is a conundrum. It's only playing on words. When the officer comes to his notice, what is the cumulative balance you may consider? If you are lucky, the cumulative balance is less than 5 lakhs. Still, he can ask you how it become less than 5 lakhs. And you know that similar of transactions shown in the profit and loss account. Credit side is income, debit side expenditure is disallowed. 140th threshold is crossing above 50 lakhs and so on. So today you take it. There are judgments of Madras High Court recently last week also. They said jurisdiction, you have no case. Merit, you may have a case. 3. Section 43 also provides for levy a penalty for failure of furnishing inaccurate information on the foreign asset on the same lines as 42. What is the difference between 42 and 43? I agree with the querist. Thank God they did not envisage this distinction. If each section operates separately, then the rigor of the section is mild. Next. Other questions are the circumstances under which prosecution can be lodged in terms of 49, 50, 51. Cartridge memorandum is very interesting, worth of non-disclosure of information. Perisami Raja had some, am I right? Yeah, Perisami Raja had some property and is not alive. So departmental authorities issued notice for prosecution. The son said, only my father's friends know about my father's acquisition. So he went and met their father's friends, and father's friends said, only the auditor knew, and auditor had died by the time. The question was, the department said, you are not cooperating with us, we'll issue prosecution. Madras High Court said, why don't you listen to your side of the story and listen to the petitioner's side of the story? Take some evidence on record, which is what we are going to discuss in the subsequent slides, to show that what are the evidences that you should be able to substantiate if you want to defend these proceedings. So I repeat the theme. So far, I mentioned to you that this is highly draconian. It is not user-friendly. It is actually abuser-friendly, obviously unfriendly. Next slide. This is a video I'm going to play for 1.5 minutes. I kindly watch this interesting piece. Further discussion after the video.
What did you purchase on this trip that's coming in today?
Just clothes,
Clothes? What's the value of your clothes?
maybe around $1,000.
$1,000? Do you have any gold with you today?
Gold is mine. I didn't buy anything.
What kind of gifts did you get?
No gifts.
You didn't get any gifts. All right, please put your luggage up on the belt. Do you have any food, alcohol, tobacco of any kind?
No.
Open that up for me. What is that exactly?
Sound of desserts.
Break one open for me, please. You can fill that up. Wow. I thought you didn't buy jewelry.
That is my mom's gift.
I didn't ask you if it was a gift. I asked you if you bought any jewelry.
Oh, I mean, I didn't buy with my money.
I specifically asked her if she bought any gold or received any gold on the trip. She declared that she had not.
They gave it to me. I didn't buy it.
Even if you get gold as a gift, it's still a new item coming into the U.S. and it's dutiable. You have the receipt. It's in your possession. The receipts were for 3 days ago, so I know it's brand new. So right now it's for gold. Where are the receipts for this?
Those are long back.
When?
It's a 3 years back.
When was the last time you wore this?
I wore it in India
Yeah. Where?
for a wedding.
Show me a picture from the wedding.
There is a picture in my ceremony I wore.
Okay. When you bought that necklace in India last time, did you pay duty when you came into the U.S.?
I think so.
Pay tax on it?
I don't remember.
You don't remember or no?
I don't remember.
You'd
My
remember if
husband
you paid tax, I think. Did you declare it? No. Let's match these up. So we have a necklace, earrings. Where's the receipt for this one right here?
Oh, these are old ones.
Why are they in a new box?
I put it there for the safety.
Why didn't you put it in the other box?
That is full, right?
No. There's only one in there, there's two in there.
Traveler returning from India keeps skirting the truth about her gold.
Why didn't you tell me you had jewelry? I don't understand.
I mean, why
You know I'm
would-
gonna open your bags.
my mom gave it to me, so
The receipt actually has your credit card information. She said, I'm gonna go weigh this, okay? She doesn't have receipts for all of these items, but she has receipts for most of them. So when that happens, whatever doesn't have a receipt, I weigh it. So you declared 1,000 and no jewelry.
I mean, I bought a clothes $1,000.
Sure.
I spent
So
my
you
money.
still have $1,000 in clothes and $4,977 in jewelry.
I mean, that is all my old jewelry, right?
These are the new receipts from the
No,
jewelry.
those
That's
are all
bought on the
rupees.
12th. I just
Okay.
converted it.
It's a 4,000.
There you go. Indian rupee, right?
Okay, okay.
That's where you were.
Okay.
And it's pretty clear. I'm gonna go talk to a supervisor. Cleared $1,000 in clothing, no gold. One of them $4,900 in gold. And she admitted last year of bringing a necklace in and never paid duty on it either. Charge him? Or you want me to seize it?
How much gold are we talking about in pieces?
5 pieces.
5 pieces?
All right. Since we've never stopped you before, today we're removing your exemption and just charging you duty.
Okay.
It's a luxury. If you fail to properly declare the merchandise, the exemption is removed from you. If you do this again, we're seizing your gold. All of it. Got it?
Yeah.
This is your one and only warning. You're going to pay duty today.
How much?
It will be $353 US.
Really? 353 for gifts?
Well, that's because you didn't declare it. If she did misrepresent herself, she would have paid far less today if she would have honestly declared what she had. Please exit over there by the cashier cage.
Yeah, going back to the slides. Next slide, please. So now you saw the video clipping. It's just not to divert your attention, but to show that an external agency outside India who has the knowledge with the tip of his fingers of source and so on. So what is the role of professionals by seeing this video and whatever I've discussed is that knowledge and awareness of the facts, fully respect of each associates in the family tree and the holding abroad. Prepare the cash flow and fund flow after considering all aspects of the case. If need be, refer to wealth statement and restitutive proceedings. In today's context, please ascertain that there are no enforcement directorate proceedings, money laundering proceedings, FERA, FEMA, civil suits or criminal proceedings. I'll add here electoral bonds. Any purchase electoral bonds or Bitcoin deals. Also ascertain certain deposits made in cash and the impact of demonetization and certain ESOP issues. Seek legal advice after analyzing the pros and cons to pursue or not to pursue the matter, and if appropriate, to challenge the proceedings by writs or other statutory appeals. Also advice on compounding of penalty, etc. Next slide. Now, I'll also want to add something in the earlier slide, but employees. You have to get all the details of their travel, the stay, and so on. The tax equalization and protection policy, that is the ESOP and other insurance policies. Salary paid outside India. Exemptions allowed or overseas salary and allowances. Tax on trailing liabilities. Overseas stock incentive schemes. Overseas pension, social security, or insurance scheme. This is from the angle of the employee. If you are advising the employer or individuals who qualifies as resident and ordinary resident, unreported foreign income and assets, foreigners in India for long term, overseas trusts, incomplete source reconciliation for foreign assets, inadequate evidence for source of foreign assets. These are the additional thing which you have to collect. Now I go to the next slide. Now, whatever evidence you give, is it acceptable to the department? So you have to have a trial run inside your office. First, that's why I quote a source of Quest of Justice by Harold Potter, who is an authority on burden of proof and onus of proof. He says that rules of evidence do not necessarily ensure justice. Supposing you show, I bought jewelry, that's not enough. You might have exchanged old jewelry for new jewelry that may not come in the bill. So you have to trace, ask the client or the SSC, have you exchanged old jewelry for a new one, or this is a fresh one or borrowed one, or somebody has pledged it with you? Because at best, they are designed to mitigate the danger of injustice. Example, hearsay almost certainly does exclude many untruths. Furthermore, an expert in sifting evidence is less likely to be misled in the absence of rules than one who is not so expert. The source is Quest of Justice by Harold Potter. Now, I want to request each one of you, if you cannot substantiate any data, kindly get an affidavit from each of the persons who is trying to help you out and explain the sources at the earliest point of time before any notices are issued. And there should not be any contradiction in getting an affidavit of your own kith and kin or somebody who is going to explain along with you. Yeah, next slide. So what's the way forward? What are the cautious approach? To me, any notice comes into BMA, do not ignore. Advise the client accordingly to cooperate as much as possible. So I've already told you the roles of professionals. I've also added something about employer's perspective, employee's perspective. File suitable declaration or return under BMA. Now it's completely gone. In case another BMA comes and gives you a leverage, there's a hope that, there's always light at the end of the tunnel, but another train may come in the opposite direction. Be aware. File the revised return under the Income Tax Act if the time limit is available as a protective measure. Supporting case law, I told you about the Madras High Court in Karthik Chidambaram's case. Analyze the limitation aspect of the proceedings under both the Act's example, 3 to 10 years under the Income Tax Act and under the FERA and FEMA and BEMA, or in Money Laundering Act, or even Enforcement Directorate and so on. Under BMA, seek for RTI. I'm sure they won't give. If applicable, or seek for inspection of records of the department, IT and BMA, and other authorities exercising jurisdiction under Section 10 relating to assessment. Next slide. So far, I've discussed the historical aspect, scheme of the Act, important expressions, specific issues, case law analysis, FEMA, Income Tax Act, rule of evidence and onus of proof, role of professionals, and the way forward. Next slide. Is the Black Money Act user-friendly? It is not user-friendly, as it seems. Neutrality should be attempted in order to comply with the draconian law. Now, Suresh again has raised a point whether RTI can be elaborated. I can tell you RTI, they won't give. The reason is Even in my own income tax return, if I ask, only then they will give, because of the right to privacy. After Puttaswamy's case, income tax department or anybody are not giving information straight away. And though it is correct to say that there is neutrality, the flip side of it is that the black money earners are subjected to injustice because you think it's unconstitutional, you think it's draconian. But at whose cost? At the cost of the innocent, ignorant persons who do not indulge in black money. That is why the legislatures bring the level of taxation to 30% to completely hoodwink the public, saying that they are paying equal rate of tax, but they enjoyed the money all these years is completely lost style. This is where the role of the chartered accountants, professionals assume considerable importance. They should rise up to the occasion and advise the client suitably within the law. A Proudhon is one of the French philosophers who says that every law has a loophole for one who finds it. So it is for each one of us to find what is the loophole. Can you call the asset as not located outside India? Can you say you filed a revised return? Can you say it's shown part 3 if it's an old act? Can you say I've shown it to the wealth tax or estate duty and so on? Now here, there is one interesting anecdote of Chris Rock. One person said, wealth is not about having a lot of money. It's about having a lot of options. So you have an option to park it outside India, option to park it here, park it outside in a trust, or keep it in tax havens. Don't bring it to India, incur expenditure outside India, money laundering, hawala. It's all options are available. It's not, that's the wealth. The real wealth is not in the bank account. Next slide. So I will conclude, but 2 more slides I will about to mention. If you are neutral in situation of injustice, you have chosen the side of the oppressor. If an elephant has its foot on the tail of a mouse and you say that you are neutral, the mouse will not appreciate your neutrality. Robert Greene in Gasol. Now I'm going to add one emotional aspect of it here. I discussed with you about 7 or 8 of the laws which had like Binami Act, VDIS, PSVS, Samadhan scheme, then income declaration scheme, electoral bonds, and BMA. The VDS scheme came for the first time in 1976. I have an emotional note about the Salem Chartered Accountants when my brother V.S. Varadarajan was no longer alive now, had to come to Chennai by car with 4 chartered accountants and deposit the declaration on or before 31/12/1976 midnight. They did go, left Salem in the morning. They went and deposited by about 2:30. After that, they had lunch and they came back to Salem by car. And my brother was sitting at the back, had to come in front. There was a major car accident in near Madurantakam, and all 4 of them were in the road. I happened to be in Salem. I was at the college, so I'm in hostel, so I rushed to Salem. Happened to be around, and I found the 4 chartered accountants were actually virtually in a very chaotic position. I don't want to name them because it may not be proper for me to say that. But the entire fraternity of chartered accountants in Salem came to us in our house when my father was alive, and they shouldered, all our negative emotions, and they were waiting for my brother to reach Salem. And of course, Varadarajan came alive, and he stood for about so many years subsequently. And then it was an agony which I have to record here after, because my brother Ashok and Ramadri are here there in the scene. I want to say thank you to all your elders in your respective families, because you're all next generation. You may not know this. And lastly, I want to say that in the lighter note, if anybody has, somebody wants, Ashok asked one more question: can disclosure of foreign assets in subsequent ITR absolve a person of non-disclosure of ITR? I think it's an interesting point. You try, but I'm not sure. I don't think they will accept it, because once a disclosure is not shown in the proper return, that's why I told you the injustice. You can only remove the injustice. You file and try, but I don't think it's possible. I don't think it's correct. So if I have white money, then I'm scared of demonetization. If I have black money, then BMA and other laws will apply. If I have a paperless currency, then somebody will take the money from me by cyber crime. And if I have no money, then IBC will take care of me. And if I'm a chartered accountant, NEFRA will catch me. If I am a lawyer, nobody can catch me because no lawyers is too strong. With this note, I extremely and once again record my deep sense of appreciation to Salem branch and others. And I could see there are about 64 participants on a Saturday afternoon is something that's really great. And I wish to any questions are sought, I'm willing to take it up. Thank you, Harini.
Thank you so much, sir. So, members, if you have any questions, you can unmute yourselves and post your questions. We'll just wait for some questions here.
Anyway, one small thing is Lenin once said, and Frank Funter of the US Supreme Court said, there are 3 rules of learning which you have to follow. First, you must learn. Second, you must learn. Third, you must learn. This is the only solution which was told to us in a YouTube conference by the Chief Justice of India, that unless we learn in today's context, we are nowhere. We have to learn every day.
There's a question. Is it necessary for an NRI to disclose foreign assets in return of income?
In NRI in India.
In India, yeah.
Yeah, world income is tax section 5. Section 5 cannot be obligated. Section 5 and 6.
So, the person is a non-resident. So for him, is it?
That's what I'm asking. If it is non-resident, only BMA will apply.
Okay.
You need not show it in India. That's why I'm telling you, if the origin and source of investment is outside India, you're called upon to respond to the respective country. That is where the debate is. What is legal outside India, you can show. What is illegal in India, how can you show in India? For example, betting. How can I show it in India? I'm a resident, but I park the money outside India, but I can't show it elsewhere. Correct. Ashok also says Schedule FA will apply only to the resident. I agree. Quite right. Anand Patsadi says, is there any abysmic limit for asking?
Is there a basic limit for taking action? For example, I won $1,000 in a game and parked it outside India. Will any action be taken?
See, if I am the officer, I'll exonerate you today. That's all. If the 1,000 becomes 2,000 tomorrow, is it cumulative or this thing? See, it's a question of intention. It's less than 5 lakhs, they don't take action.
But as per
But why did you give
there is no
$1,000 to me? I don't
refund,
mind.
is it?
5 lakhs. Some
5
rules
lakhs.
it is there, 5 lakhs. 5 lakhs Indian currency or foreign currency, I don't know. I'm just saying 5 lakhs. One of the CBDT circulars. Now, whatever I discussed today, it applies to all the 7 acts. If you don't get prepared with all the details, data of foreign source, foreign savings, tax havens, and tax credit, we are in trouble.
Yes, sir. Members, is there any other questions? We'll just wait for a minute and then wind the session.
I hope I stuck to the time. I didn't want to cross 12:45.
Yes, sir.
You can ask Suresh or somebody because he's the karta for the meeting. Suresh, why don't you come on live and say something?
Yeah.
Or one வார்த்தை சொன்னா 1000 வார்த்தை. The Rajinikanth
Thank you, Jayakumar, for having taken up this topic very seriously. Hello.
Yeah.
Hello.
Yeah,
Yes, sir, you are audible.
Hello.
Audible.
Yes, sir.
Am I audible?
Yes, yes.
Absolutely.
Okay. Thank you, Jayakumar, for having taken up this topic. My big request, you have done a wonderful job, and thanks for opening all of our eyes. It was a small beginning. I think we'll have a long way to go, and you have answered most of our questions. And I really thank you for the involvement. The lecture presentation was excellent. Thanks, Harini, for a wonderful follow-up with Jayakumar. And thank you very much.
Yes, sir. So there's one last question. If the assets are frozen outside by the foreign state, can I still be held responsible for not disclosing it?
If his assets are frozen under what law? Is it FEMA? Then you're out. Then they
Okay.
can't act on the BMA.
Okay.
That's the issue. Supposing a person is arrested, he's carrying some gold, he's arrested and outside India. How can he comply with the law in India? Because he's arrested, he's gone. He's an accused. So that's the thing.
No, supplementing, sorry.
Yeah.
No, supplementing Ashok's query on
Mm.
disclosure at a later date.
Mm.
Will it still not be a disclosure?
That's what I'm saying. Disclosure, there is no definition of disclosure in any enactment. Whereas only voluntary compliance, section 59 and 60 under the BMA. Voluntary compliance can also be disclosure, but there are certain conditions given there. There should be a time limit under 139(1) and all that. In 59 and 60, I did not elaborate. But nevertheless, as I told you, disclosure by one person in any year, to me, yes, there is partial compliance. Supposing I simply say my money is with Suresh, is it disclosure? Whose disclosure is it?
Oh, you are bringing both.
Correct. That's why that is a problem when that lady in that video had said my mother had given.
Yeah.
If you're the officer, will you keep quiet with this lady or will you trace to the mother?
Okay.
You'll go back to the mother. How did mother get it? That's why the problem of 100 years, I do agree. It is a very cascading effect.
That's
It's a cascading effect. That's correct. Supposing I found in the road some $1,000 in abroad, I didn't show. I didn't know where to give. Am I committing a crime? Whom should I go and disclose to? Which return I'll show? You'll say, how did you bring the money? Okay, in so many people's houses, even now in safe vault, people keep dollars, even in Salem and Madras and elsewhere. Is it disclosed or not? How to find out? What records you will require? How do you keep the safe vault password? Who will keep it?
We have a classic case of our MP having been found with overseas currencies.
Correct. So these are the issues. I mean, there are a lot of issues can still generate, but I think they're only hypothetical.
Okay.
One more question.
That's why I told you. Yeah. That's why I told you what Palkiwala said. Did I tell you that? I don't know whether Suresh heard it. Palkiwala said the cases in India are won by 4 factors. 1, the talent of the lawyer. 2, the talent of the judge. 3, the facts of the case. 4, the luck of the client. He gives a long pause and says in the reverse order. It's the luck of the client, the facts of the case, talent of the judge, and talent of the lawyer in the last. So that's how the cases are won here. I mean, it's only a probability and prediction.
That's what my uncle always used to quote.
Correct.
So there's another question.
Yeah,
Whether
yeah.
amount received by resident from foreign source. The person is a resident in India. So what type of information is required to be disclosed in his ITR?
No. See, in fact, there are cases where every information is given. Information is given from bank account, where it is transferred in Chennai or Salem, how it is drawn. Everything is given. Even then, they are not satisfied. Minimum thing you have to give is the real source. Is it money changers who gave the money, or directly to your NRO account, NRE account, or other account permissible in law, or have you got the permission of the Reserve Bank? And people still have the permission of the Reserve Bank. Still, the questions are asked by the department. It's not binding on us. You know, under the RBI Act, section 45 or so, it says that no other law can apply if the RBI Act is applicable. The Supreme Court says that's not binding at all. Any law can ask, they can override RBI. Unfortunate. RBI clearly says no other law can apply, only RBI Act will apply, but Supreme Court says no. That's it.
Yes, sir. So thank you so much for the enlightening session. I now request the Vice Chairman and Secretary of Madurai Branch, CA Chairman, to enter the vote of thanks for the session.
Thank you, Madam. Good afternoon, all. It's my honor to deliver a vote of thanks for the today's session, navigating through the Black Money Act 2015 by Senior Advocate of Madras High Court, V.S. Jayakumar sir. I thank you, sir. Thank you, Jayakumar sir, for navigating us through the Black Money Act from the preamble to penalties of the Act. Thanks for your eye-opening session, sir. Thanks for the knowledge sharing about what is the connections between the Black Money Act and other allied acts, Income Tax Act, and what is the importance of the correct disclosures with authorities through the nice video, sir. I thank Harini Madam, the chairperson of Salem, Mr. C. Asovan sir, the chairman of the Erode, C. Jayakritika, the chairperson of Madurai, and other committee members of the branches for organizing this wonderful session. I thank you all the senior members, the fraternity members who have joined this session and make the session more interactive. Once again, I thank you all for your active participations. Thank you all.
So thank you so much, sir. We'll
Thank you very much.
Thank you.
Yeah, thank you. Thanks all of you. Thank Ashok, thank Suresh, thank Harini.
Thank you. Thank you very much.
Yeah, thank you.